Okay, well, good afternoon, everyone, and welcome to this webinar training titled Maryland Sentencing Guidelines 101, Everything You Need to Know About the Guidelines and Recent Updates. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, also known as the Sentencing Commission, or MSCCSP for short. The sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in this training and staying up to date on sentencing guidelines is important because it helps to promote the consistent application of the guidelines. Although the MSCCSP staff is a small group, please know that we are here to help, and you should feel free to ask any questions. My colleagues, Sarah Bowles and Stacy Najaka, are also attending this webinar this afternoon and will be monitoring questions through the chat box throughout the course of the presentation. We may not be able to address all questions today, but we're always available via email or phone. The MSCCSP contact information is available on the Commission website at msccsp.org. Finally, please note that today's webinar is being recorded and that this video or a similar webinar video will be made available on the MSCCSP website. So before we get started, I just want to go over some general Zoom webinar housekeeping, which I know we're all very familiar with Zoom at this point. I did just want to note that we are asking participants to remain muted throughout the course of the presentation. That's just to ensure that we get through it in a timely manner. But that said, we certainly encourage any questions you may have. So please feel free to submit questions through this chat box here. And as I mentioned, my colleagues, Sarah Bowles or Stacy Najaka, will respond to them. We do encourage participants to submit your questions to the whole group, just so everyone can benefit from seeing the question as well as the answer. But that said, if you're not comfortable doing that, that's fine. Please just make sure that you're sending the message directly to either Stacy Najaka or Sarah Bowles so that they can answer it. If you send it to me, I'm not going to be able to see it until the end of the presentation. So again, if you can just make sure that this little microphone has a red slash through it just to ensure that you're muted, and then it's up to you whether or not you would like to keep your video on. So let's move forward to the agenda for today's training. Since most of you are probably somewhat familiar with the guidelines themselves, I thought it'd be helpful to start the presentation by providing some information about the background and goals of the MSCCSP itself. Then we're going to get into the various sections of the guidelines worksheet and how they should be calculated. We're also going to look at some special applications that adjust the calculation of the guidelines in certain scenarios. And then throughout the course of the presentation, we will be focusing on some recent updates, including the pending revisions to the drug and property matrices that will be going into effect on July 1 of 2022. Okay, so let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. Maryland was one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary, and then in April 1979, the Sentencing Guidelines Advisory Board, formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. Then the guidelines in Maryland were in effect statewide for about 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. And thus the MSCCSP was born. Now, the enabling legislation that created the current day Sentencing Commission outlines a statement of intent for the MSCCSP in Criminal Procedure Article 6-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that sentencing policies should reduce unwarranted disparity, including any racial disparity, in sentences for criminals who have committed similar crimes and have similar criminal histories. Second, sentencing policies should help citizens to understand how long a criminal will be confined. Third, sentencing policies should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. The Commission has a few primary responsibilities to help address these goals. The first responsibility is to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through the second major responsibility, which includes the collection and maintenance of an extensive database, which is assembled via the data submitted on the sentencing guidelines worksheet. The Commission uses the guidelines data to monitor circuit court sentencing practice. It examines sentencing patterns and reasons for departure for specific offense categories and within individual cell ranges to consider changes to the guidelines when necessary. And finally, the Commission is also responsible for providing training to criminal justice practitioners to promote the consistent application of the guidelines and accurate completion of the guidelines worksheet. The MSCCSP is an independent, objective agency comprised of a balanced and diverse group of 19 criminal justice practitioners from all three branches of government. The Commission is chaired by Judge Brett R. Wilson, a circuit court judge in Washington County. The membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate court's representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. The MSCCSP makes decisions with respect to the guidelines after deliberating with the many stakeholders that comprise the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the Commission. Now let's get down to the basics. What is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories, they're treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The sentencing guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and his or her crime that are most relevant to the sentencing decision. And they help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. Now let's discuss some of the basic principles of the sentencing guidelines. The sentencing guidelines in Maryland are voluntary, so judges may, at their discretion, depart from the guidelines. They're also intended to be primarily descriptive. This is, the guidelines should be reflecting the actual sentences and may be amended when the data indicates that sentences are not consistent with the recommended ranges. Finally, the guidelines are generally limited to cases that originate in the circuit court, so the guidelines do not apply to district court cases, jury trial prayers and appeals from the district court. They are guidelines eligible, but only if a pre-sentence investigation is ordered, which is a small percentage of those types of cases. Now let's discuss how the guidelines data are utilized after sentencing to inform policy decisions. So generally speaking, the data are assessed to review sentences and helps to inform the Commission whether changes to individual cell ranges or offense seriousness categories are warranted. The data are also used to monitor compliance and to see how often judges depart from the guidelines for specific offenses and offense types. And finally, the data is used to inform the legislature of sentencing patterns for specific offenses or offense categories. So every year we do publish an annual report detailing various sentencing trends throughout the state of Maryland. All of our annual reports are available on our website. So if that's something that may be of interest to you, we certainly encourage you to check those out. So now that we've discussed a little bit of the background and the goals of the MSCCSP, let's move on and review how the guidelines are calculated. And I want to begin by discussing what constitutes a single criminal event versus multiple criminal events. Now, we define a single criminal event as one or more crimes committed in the course of the same transaction, whereas multiple criminal events means that there was more than one criminal transaction committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates, but generally offenses that occur on different dates are almost always considered separate criminal events. Next, I want to discuss what constitutes a sentencing event. A sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. And when there are multiple criminal events, which you are often indicated by unique case numbers or different offense dates, if they're sentenced by the same judge on the same day, they constitute one sentencing event, meaning that there's one set of guidelines worksheets and one overall guidelines range calculated between those cases. And for those of you who are familiar and utilize the MAGS application, it's important to remember that when you do have multiple criminal events being sentenced by the same judge on the same day, how they constitute one sentencing event, meaning that all of the worksheets for those cases should be initiated under one MAGS record or worksheet ID. That's to ensure proper calculation of the overall guidelines range. I also just want to note that merged or null prost offenses by guidelines rule should be removed from the guidelines worksheet and are not reflected. Now let's take a look at an example to illustrate how one sentencing event may include multiple criminal events. And I know the text is a little small here, so just bear with me. But this example shows completed worksheets for two separate criminal events that are being sentenced together by the same judge on the same day. So in the upper right-hand corner here, we have a conviction for distribution, PWID, manufacture, et cetera, of PCP that was committed on July 10th of 2020. We can see it has its own unique date of offense as well as its own unique case number. Jumping down to the worksheet in the bottom right-hand corner, we have an assault first degree from January 25th of 2021. Again, has a different date of offense than the PCP, and again, has its own unique case number. So by guidelines rule, each separate criminal event should correspond to their own guidelines worksheet. So even if there's only one convicted offense in each criminal event, it is still correct for them to be reflected on their own separate guidelines worksheet. Each offense will have an individual guidelines range calculated, but there is still one overall guidelines range calculated for the sentencing event. So again, that's just an example of how a multiple criminal event, single sentencing event scenario will look. So the next section to discuss is the convicted offense information. This section captures the date of offense as well as the convicted offense or offenses in a given case. So the first field that I want to point out is in this upper right-hand corner here, and this is the number of convicted offenses and the number of criminal events. Now, these numbers play a major factor in calculating the overall guidelines range, so it's important to make sure that those numbers are inputted correctly. Again, for those of you who are familiar with guidelines calculation, you know that the more criminal events you have, the higher the guidelines range will be. So when you're inputting that information into MAGS or maybe calculating sample guidelines using our guidelines calculator tool, you want to make sure that you're entering the proper criminal event numbers, again, to ensure proper calculation of the overall guidelines. And jumping down here to the convicted offense title, those can be located from our guidelines offense table. And once you select them either from MAGS or the guidelines calculator tool, the worksheet will then display the offense title, the CJIS code, the statute, the statutory maximum. If there were a mandatory minimum, that would display here, and then the case number. So the other column that I want to point out and talk a little bit about here, it's labeled with the column with the Roman numeral equivalents of 1 through 7, and that's the seriousness category column. And I'm going to divert for a second from the worksheet to talk a little bit about how that plays into the general framework of the guidelines. And most of you, again, are probably familiar, but I just want to give a brief overview of how guidelines are generally calculated. So Maryland has 3 separate sentencing matrices. We have one for property that you see here. We have one for person offenses. Those are some more violent offenses or those that may involve victims, and one for drug offenses. The guidelines were designed to take both offender and offense characteristics into account. Now, looking at the property matrix here, we can see that the column on the left-hand side that represents the offense seriousness category column. Each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And for property offenses, those offense categories range from a 7 all the way to a 2. Now, the top row up here, this represents the offender score, which we're going to get into a little bit later on, but it essentially captures components of an offender's prior record. So let's walk through a basic example. Let's say we have an offender who has no prior records. So they have an offender score of 0, and they were convicted of theft less than 100, which is a seriousness category 7 property offense. If we refer to the matrix here, we can see that the recommended guidelines range would then be probation to 1 month in that scenario. So again, that's just a basic example to show how the guidelines are calculated. So returning to the worksheet calculation process, the next section we want to discuss is the offense score section. Now this applies only to person offenses, so that those are typically ones that involve victims like assaults, robbery, as well as weapon-related offenses. Now the offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components. The first being the offense seriousness category, 2, victim injury, 3, weapon presence, and 4, special victim vulnerability. Now, the first section, the seriousness category, it provides a conversion chart shown on the worksheet whereby the least serious offenses, those being the categories 5 through 7, they are assigned 1 point to the most serious offenses, such as murder, which is a category 1, and that is assigned 10 points. Now, with regards to the offense score and the seriousness category of an offense, it's important to also note that generally any conspiracy, attempt, or solicitation shall be assigned the same seriousness category as the underlying offense. Now, with that being said, there are some exceptions for some of the more serious offenses. For example, attempted first-degree murder is a category 2 offense, whereas first-degree murder is a category 1. And the same is true for rapes, etc. So if you ever have a question about seriousness categories for some of those more serious offenses, if they do involve a conspiracy, attempt, etc., please refer to our guidelines offense table for the proper seriousness category classification. So moving on to victim injury, it is defined in the Maryland Sentencing Guidelines Manual as reasonable proof of injury and may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the convicted offense. So non-permanent injuries are assigned 1 point and permanent injuries or death are assigned 2 points. Now, psychological injuries shall be based on confirmed medical diagnosis or psychological counseling or treatment and is presumed not permanent unless otherwise demonstrated. And physical injuries shall be more than minimal. Now, I will say with regards to victim injury, this is a component of the offense score that we do tend to get a lot of questions about. For example, practitioners have questioned in a scenario where there was a victim of a stabbing and the victim sustained a scar as a result of that stabbing. Would that scar constitute a non-permanent injury or a permanent injury? And while our guidelines manual does provide some guidance, it's just not possible to address every single scenario or circumstance that may arise in a given case. So there is some discretion when it comes to scoring victim injury points. Ultimately, if there's a discrepancy between how the state or the defense feels those points should be reflected, those questions should be brought to the judge's attention at sentencing, and the judge will make the ultimate determination as to the proper number of points that should be reflected. So I also want to highlight a recent update regarding the scoring of victim injury points in child pornography cases. So again, Part B of the offense score, victim injury, instructs that 2 points shall be scored for person offenses if victim injury occurred and the injury was permanent or resulted in the death of the victim. In response to testimony that was provided by an assistant state's attorney at the MSCCSP's 2020 public comments hearing, the commission voted to adopt revisions to the guidelines manual and COMAR to instruct that permanent victim injury points shall be awarded in cases involving evidence of child pornography. Specifically, the revisions provide the added instruction that effective October 1, 2021, offenses involving photographic or video evidence of child pornography shall be scored as permanent victim injury. This language is intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography and is not limited to convictions for the possession, manufacture, or distribution of child pornography. So for instance, this rule may apply in cases involving the following types of offenses. If evidence of child pornography is present: sexual solicitation of a minor, sextortion, visual and camera surveillance of a private place, obscene matter, prostitution, human trafficking, or electronic harassment. And these revisions recognize that photographic and video evidence of child pornography often exists in perpetuity, and that the victims of these crimes suffer lasting psychological consequences and are often re-victimized every time an image is viewed, possessed, or distributed. So again, effective October 1, 2021, permanent injury points shall be scored in these circumstances. Now moving on to part C, which is weapon presence. Now weapon presence is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. I also want to note here that when calculating the offense score, a judge may include factors known to the judge when making this decision, even if they are not within the scope of the convicted offense. So for example, a defendant who is charged with armed robbery but pleads to robbery, points may still be awarded for firearm or weapon presence in that scenario. Now, before we discuss part C of the offender score, which is special victim vulnerability, I'm going to generate a poll question regarding the circumstances in which an individual qualifies as a vulnerable victim. So I'm going to generate this poll in a moment here, and your answers are anonymous. But it's nice to have these exercises because these are common questions that we do receive. So this poll question is asking, would a victim who is known by the defendant to be pregnant meet the criteria for a vulnerable victim? So I'm going to go ahead and launch this poll question. Again, I'm going to give everyone a couple seconds if you can just go ahead and make your selection, and then I'll share the response and we'll talk about it. So again, would a victim who is known by the defendant to be pregnant meet the criteria for a vulnerable victim? Yes or no? Have a little over half of the participants submitting their answers. I'll give everyone 5 more seconds. Okay, let's go ahead and share these results here. So 89% think yes and 11% think no. So let's go ahead and see the answer here. And the answer is yes. So let's go ahead and take a look at this special victim vulnerability criteria in greater detail. So here are the factors that are used to determine if a victim is especially vulnerable. If the victim's younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. Now, I want to note that effective February 1 of 2021, this red text that you see here, this went into effect and was added to clarify that instances in which the offender knew or should have known that the victim was pregnant, unconscious, asleep, or intoxicated, they are examples of a temporary physical or mental limitation, and the offense score shall include 1 additional point for special victim vulnerability in these instances. Okay, so moving on to the next section here, which is the offender score. Now, the offender score is a summary scale ranging from 0 to 9, and this measures an offender's criminal history, taking into account 4 factors. Part A, relationship to the criminal justice system at the time of the instant offense. B, juvenile delinquency. C, prior adult criminal record. And D, prior adult parole and probation violations. So let's take a look at each of those sections in greater detail here. Before we get into part A, we're going to generate another poll question. This is a very common question that we receive. So this is a true or false. 1 point should be scored for part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. Is that true or false? So I'm going to go ahead and launch this poll question here. Give everyone a couple seconds to respond, and I'll read the question one more time. So 1 point should be scored for part A of the offender score, relationship to the criminal justice system when the incident offense occurred, if the defendant was on pretrial supervision at the time the incident offense occurred. I have a little over half of the participants have their answers locked in. Let's give everyone about 5 more seconds. Okay, let's go ahead and see the results here. So this one is a little more split. We have 70% think true and 30% think false. So let's go ahead and take a look at the answer here. Whoops, I apologize. And the answer is false. So let's take a look at why that is. So 1 point should be scored if the offender was in the criminal justice system as a result of an adjudication of guilt as an adult at the time the offense was committed. So an offender should receive 1 point if they were in the criminal justice system, for example, on parole, probation, etc., as a result of an adjudication of guilt, which is why pretrial supervision generally would not count, since the defendant had not been adjudicated guilty in most circumstances when they are on pretrial supervision. However, if they had been adjudicated guilty of an offense and was still on pretrial supervision pending sentencing, in that scenario, 1 point would be scored for Part A. But generally, pretrial supervision does not constitute a relationship to the criminal justice system. So next I want to highlight, this isn't so much as a relatively recent update since it was about 2 years ago at this point. But for those of you who may be new to the guidelines, I think this is helpful just to point out. So effective February 1 of 2020, Part A of the offender score may now differ across offenses in multiple offense sentencing events. So when you're viewing the worksheets where Part A of the offender score does differ between offenses, a score of 0 points for Part A of the offender score will be marked with a blue circle, as we see in this upper left-hand corner here for that worksheet. And then a score of 1 point will be marked with a green circle, and the individual guidelines range with 1 point will be recorded in green. So again, just wanted to point that out. If you're viewing the worksheet and maybe at first glance don't understand why there may be a difference in color, that's why. It's because Part A of the offender score differs between those offenses. Okay, so moving on to Part B, juvenile delinquency. So 0 points are scored if an offender is 23 years or older by the date of the most recent instant offense, or if the offender has 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under than 23 and has 1 or 2 findings of a delinquent act within 5 years of the date of the most recent instant offense. And 2 points are scored if the offender is under 23 and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. So some additional instructions that I want to highlight here is that only 1 finding of a delinquent act, which is the finding of facts sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing. So if you have multiple findings of a delinquent act, if they relate to a single adjudicatory hearing, the individual completing the worksheet shall count only 1 finding of a delinquent act. And when the defense or the state can show that a finding of a delinquent act did not result in the youth's adjudication as delinquent at a juvenile disposition hearing, that finding of a delinquent act shall not be scored as part of the juvenile record. Now moving on to Part C, which is the prior adult criminal record. Now, aside from a few exceptions that are further noted in our manual, the prior adult criminal record generally includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. And while we're on the topic of prior adult criminal record, we're going to break it down and get into the criteria in a moment here. But I also just want to discuss, again, maybe not so much a relatively recent update at this point, since it went into effect on July 1, 2020. But again, it's just good information to know that effective July 2020, the MSC-CSB clarified instructions for the computation of the prior adult criminal record component of the offender score when the offender's record includes a prior military adjudication. So when scoring the prior record, if an offender has a finding of guilt by a general or special court martial, the military adjudication shall be matched as closely as possible to the closest analogous Maryland offense. Conversely, military adjudications imposed by an Article 15 proceeding or summary court martial shall be excluded. Further, if a military adjudication has no equivalent in Maryland law, or requires as an element of the offense the defendant's service in a military force, so for example, desertion or absence without leave, the offense shall be excluded from the prior adult criminal record. And if there is ever a question as to the analogous guidelines offense for a military adjudication, that question shall be brought to the attention of the judge at sentencing. Okay, now before we get into the prior adult criminal record, let's do another poll here. Now, true or false, only one adjudication per criminal transaction should be counted towards the prior record score. Go ahead and launch this one. And go ahead and make your selection. Again, your answers are anonymous. These are just good exercises with questions that we receive pretty frequently. So it's just good information for everyone to know. So true or false, only one adjudication per criminal transaction should be counted towards the prior record score. We have about half of the participants locking in their answer. Let's give another 5 seconds. Okay, and let's take a look at these results. So 76% think true and 24% think false. So let's take a look at the answer here. And the answer is true. So let's break down the calculation of the prior record score in greater detail. Now, this is probably the most complicated component of the offender score. So we're going to walk through the various steps, and then we'll actually walk through a hypothetical criminal record and figure out what that score should be. Now, the first step is to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple convictions that stem from the same criminal transaction, you want to identify the offense with the highest seriousness category in that criminal transaction. Step 2 is then to count the number of offenses in each seriousness category using only the offenses identified in step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level. And before we do that, I do want to note that Maryland allows for what we refer to as the criminal record decay factor, meaning if the defendant has remained free of criminal justice system involvement, meaning they've been off parole, probation, mandatory supervision, etc., for 10 years prior to this instant offense, the criminal record shall be reduced by 1 level. So if the defendant's prior record is initially calculated to be a moderate, but the history meets the criteria for the criminal record decay factor, it would then be reduced to a minor record level. So here's a screenshot of our prior adult criminal record matrix that is used to determine the level of the defendant's prior criminal record. Now let's walk through an example here. Let's say we have a defendant who back on October 1st of 2013 was convicted of second-degree assault and aware carry transport of a handgun. Now, since there are multiple convictions stemming from that transaction, we would only count the more serious offense, which in this case would be the second-degree assault, which is a seriousness category 5 person offense. Then on July 28th of 2016, we have a burglary second degree, which is a seriousness category 4 property offense. And then on 12/12 of 2020, we have a resisting arrest, which is a seriousness category 7. Now, among these 3 prior convictions, the burglary second degree has the highest seriousness category of 4. And since we only have 1 conviction within that seriousness category, we are going to refer to this first box here. Now, the defendant's prior record will result in a moderate level due to the fact that there are less than 3 other convictions, and it would increase to a major if it happened to be combined with 2 or more offenses in categories 4 through 6 or any 6 offenses in general. So again, that's just a basic example of how the prior record would be calculated. I know, again, that this can be a bit confusing. You may have questions. So please, if you ever have questions about scoring the prior record, always feel free to call our office. And I'm happy to walk through those scenarios with you. Wrapping up with Part D of the offender score. So this is prior adult parole and probation violations. So 1 point is scored here if the offender was ever adjudicated in violation of parole or probation, or was convicted of an offense while on parole and probation, unless the adjudication or conviction arose from the offense or offenses of this sentencing event. So in this case, you would not want to give a point simply because the defendant was on parole or probation at the time of the incident offense, because the defendant will have already been given a point in section A for being on parole and probation. They need to be adjudicated in violation of parole or probation to get a point in this category. Okay, so that wraps up the offender score. Now let's move on to the recommended guidelines ranges. So I noted this a little bit earlier, but when you're viewing the worksheet, you'll see that there's space for each individual guidelines range per convicted offense, and then there's one overall guidelines range calculated based on the sentencing event. Now let's take a look at a couple of examples of how the guidelines range is adjusted due to special circumstances in a case. So here's an example of where the overall range is adjusted due to a case involving multiple victims within a criminal event, which we often refer to as our guideline stacking rule. So in this type of case, the guidelines range for each individual offense is still calculated as normal, but instead of using the highest of the upper and lower limits, the highest of the lower limit is taken, and the upper limits for each offense involving a unique victim are instead added or stacked. And if you have multiple offenses per victim, you would only want to stack the upper limit for the most serious offense. So in this example here, we have an individual who was charged with 3 counts of second-degree assault with 3 separate victims. Each count originating out of the same criminal event. Now, the overall range for this event would be adjusted to account for the 3 separate victims. And in this example, the range would be adjusted from an overall guidelines range of 2 years to 5 years to 2 years to 15 years to reflect the involvement of 3 separate victims in this event. So let's kind of recap the criteria for the stacking rule. In order for the stacking rule to be applied, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense. Only one convicted offense per distinct victim may be used to calculate the overall guidelines. And again, only the upper limits stack. Now, let's generate another poll question here. This is a very frequent question that we receive. So this is a true or false. The stacking rule can only apply towards person offenses. Is that true or false? So I'm going to go ahead and launch the poll here. Go ahead and make your selection. So true or false, the stacking rule can only apply towards person offenses. So again, those are the more serious offenses involving victims or weapon-related offenses. Have about half of the participants locked in with their answer. Give another 5 seconds. Okay, let's go ahead and share the results. So this is pretty split here. We have 55% saying true and 45% say false. So let's go ahead and take a look at the answer here. And the answer is false. So the stacking rule can also be applied towards property offenses as well. For example, if there happen to be multiple victims of a theft or fraud related case, you could certainly apply the stacking rule in that scenario as well. It is not limited to person offenses. So another scenario that we thought would be appropriate to discuss is when the overall guidelines range is adjusted due to subsequent offender drug sentence enhancements. So in this example that we see here, we show a case where the offender was convicted as a subsequent drug offender pursuant to criminal law article 5-905, excuse me. In this example, the offender was sentenced for a distribution of cocaine, which is a category 3B drug offense. If the offender had an offender score of 3, the range in this example would have been 3 to 7 years. However, because this offender was convicted as a subsequent drug offender pursuant to criminal law article 5-905, the guidelines range for that offense is doubled by guidelines rule, given that the statutory maximum is also doubled. So in this case, that would increase the guidelines range to 6 years to 14 years, given that the defendant was convicted as a subsequent drug offender. Okay, the next section of the guidelines worksheet highlighted here, this is the victim information section. These questions pertain to the rights of victims at sentencing, and again, are located in the bottom left-hand corner of the worksheet. The State Board of Victim Services has asked the Commission to collect this information on their behalf. So we certainly encourage practitioners. I know state's attorneys and parole and probation agents are mainly responsible for entering the first couple of questions, and then there are some questions that cannot be answered until after sentencing. For example, if the victim was present at the sentencing, if they gave a victim impact statement, etc. So those fields would be completed by the judge or judge's designee post-sentencing. And the remaining fields that you see highlighted here, these are the sentencing and departure related fields that are typically completed by the judge or his or her designee post-sentencing. So this includes sentence information for each individual offense, the disposition type, whether victim court costs were imposed, etc. So there are two fields located in this section that I want to emphasize a little bit further, and those are the corrections options and alternatives to incarcerations fields. Now we're going to get into this a little bit more in a moment here, but sentences to corrections options are deemed guidelines compliant, provided that the initial sentence plus any suspended sentence, so essentially as long as that total sentence falls within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. So it's important that use of any of these corrections options programs are marked appropriately on the sentencing guidelines worksheet, since it does factor into guidelines compliance. Now, before we take a look at those, I also just want to highlight this other alternatives to incarceration field. So this field captures other programs that don't meet the criteria for corrections options, but are still utilized by judges as other alternatives to incarceration. So these can include outpatient substance abuse and mental health treatment, as well as other standard alternative programs such as anger management. Capturing these programs allows the Commission to collect more detailed data that, in combination with the recidivism data, may be used to help identify effective and promising alternatives to incarceration and to help inform future sentencing decisions. So again, it's important that we're capturing these programs accurately on the guidelines worksheets when they are utilized at sentencing. So next, we're going to get into what constitutes a guidelines compliant sentence. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, falls within the applicable guidelines range. So generally, suspended time is not considered when determining if a sentence is compliant. And there is one exception involving corrections options, which we talked about a little bit. We're going to talk about it in the next slide here. I also want to note here that compliance is calculated by comparing the overall total sentence across all the convicted offenses in a sentencing event to the overall guidelines range for the sentencing event. So for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in a sentencing event, fall below the lower guidelines limit for a second offense, but the overall sentence when adding together the sentence for both counts falls within the overall guidelines range for that sentencing event. Now, there are a few qualifiers to consider regarding guidelines compliance. And the first is that effective April 1 of 2021, sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. And some of you might remember the former ABA plea agreement, but I want to note that that former ABA plea agreement disposition type, it's now been replaced with MSCCSP binding plea agreement. And the criteria for what constitutes a guidelines compliant MSCCSP binding plea agreement has also been revised. And we'll look at that in a moment here. The MSCCSP binding plea compliance rule, it follows the same logic as the former ABA plea agreement compliance rule, which was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties and the court within their specific community. So accordingly, the Commission felt it was important to define these as compliant sentences. Now, binding pleas are three-party agreements in which the defense and the state present to the court on the record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it is binding on the court pursuant to Maryland Rule 4-243 subsection C. Now, following a review of binding pleas in 2020, which included a review of definitions of binding plea agreements from other jurisdictions, an examination of relevant Maryland case law, and an analysis of data on sentences for guidelines eligible cases sentenced from 2017 through 2019, The MSCCSP agreed that the former term ABA plea agreement was not universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. Further, effective April 1 of 2021, the MSCCSP narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. So in totality, the definition of an MSCCSP binding plea is as follows. It's a plea agreement presented to the court in agreement by an attorney for the government and the defendant's attorney, or the defendant when proceeding pro se, that a court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement is binding on the court under Maryland Rule 4-243, subsection C, if the court accepts the plea. So I know that was a lot of information to take in and probably digest. So let's generate another poll question here. It's going to have a hypothetical sentencing scenario, and we're going to figure out whether or not this constitutes an MSCCSP binding plea agreement. So I'm going to read it first, and then I'll launch the poll. So the guidelines for the sentencing event are 2 years to 4 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? So I'm going to go ahead and launch this poll. And I had to abbreviate the text a little bit, so I'm going to read it again as you all start making selections. So the guidelines for the sentencing event are 2 years to 4 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? Yes or no? Okay, we have about half of the participants logged in. Let's do 5 more seconds. All right, let's see the results here. So this is pretty split, so I'm glad we're reviewing this scenario here. So we have 56% think yes and 44% think no. So let's go ahead and take a look at the answer here. So the answer is no in this scenario. So as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or a cap. So in this scenario, the court accepted a plea agreement to a sentence range, anywhere from probation to 2 years. And this is why it would not constitute an MSCCSP binding plea agreement. So hopefully that helps to add some clarification to this scenario here. Now let's take a look at another guidelines compliant sentence sample scenario. So let's say in this example, the guidelines for the sentencing event are 1 year to 5 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. So while this agreement is not an MSCCSP binding plea agreement, right, since the plea agreement involved a sentence range, it would not constitute an MSCCSP binding plea agreement. But this sentence is still a guidelines compliant sentence, since that guidelines applicable sentence of 2 years is falling within the overall guidelines range of 1 year to 5 years. So I just wanted to point out this as another sample scenario. So even if a case isn't adjudicated via an MSCCSP binding plea agreement, of course, there are still scenarios where it could constitute a guidelines compliant sentence, given that that guidelines applicable sentence is falling within the overall guidelines range. So another additional qualifier regarding guidelines compliance, which we talked about, is the role of corrections options. So sentences to corrections options programs, for example, drug court, residential substance abuse treatment, home detention, those are deemed compliant provided that the initial sentence plus any suspended sentence falls within or above the applicable guidelines range and the case does not include a crime of violence, child sex abuse, or escape. So again, this is the exception I mentioned earlier in which suspended time is considered for determining a guidelines compliant sentence. Now let's take a look at the full list of corrections options. So corrections options allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the guidelines. And they include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under Health General Article 505 and 507, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of a controlled dangerous substance, work release, or weekend or other discontinuous incarceration. So again, a fully suspended sentence in this scenario, if a corrections option program were imposed, as long as that total sentence falls within or above the applicable guidelines range, it would be deemed guidelines compliant. And then wrapping up, the last rule regarding the calculation of guidelines compliance is that sentences in which the offender received credit for time served with no post-sentence incarceration time and the amount of credited time exceeds the guidelines range, those are deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still considered guidelines compliant, even though the credit time would exceed the upper guidelines limit in that scenario. Okay, now turning the conversation to talk a little bit about the guidelines worksheet completion process. So I just want to note that the sentencing guidelines worksheet has two primary purposes. The first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216 indicates that the court shall consider the guidelines at sentencing. And the second purpose of the worksheet is to provide data so that the commission can make informed decisions about sentencing policy. So Criminal Procedure Article 6-210 then requires the commission to collect the sentencing guidelines worksheets, automate the information, and monitor sentencing practice. Now, I'm sure many of you are very familiar with our Maryland Automated Guideline System, also known as MAGS. So MAGS is now being utilized in all 24 jurisdictions, and it is the application that is used to initiate and submit official guidelines worksheets electronically. So here's a screenshot of our MAGS homepage. I just wanted to point it out to you because we do have a couple of instructional and support materials here. If you're a practitioner who may be newer to the guidelines, or you have a colleague who comes on board who may be looking for some resources. On our MAGS homepage here, we have some instructional videos. We have two. The first is geared towards parole and probation agents and state's attorneys and focuses on initiating a sample guidelines worksheet. The second is geared towards judges and their designees and will focus on entering sentence information and submitting guidelines worksheets through the system. So we would encourage you to check those out. We also have a MAGS user manual. If you've taken a look at it, you've probably noticed it's very detailed. There's tons of screenshots and a lot of information. So if you have a question about MAGS, you'll probably find the answer in there. But again, always feel free to contact us either over the phone or via email. If you have, you've probably spoken with me, and I'm always happy to help out with any MAGS related questions. I also want to point out our guidelines calculator tool. So our guidelines calculator tool is a standalone tool that can be utilized by anyone to calculate sample guidelines. So you don't need a username, you don't need a password. The only caveat is that once you enter information into the guidelines calculator tool, you really need to view the worksheet PDF and print it out at that period of time or save it to your computer, as the application won't store your information. So I just wanted to point out this tool. It's essentially a simplified version of MAGS. These first couple fields here, offender information, offender score, and list of offenses, they are identical to what you would see in MAGS. And I know that the guidelines calculator tool is a particularly helpful tool for defense attorneys who want to calculate their own sample sentencing guidelines worksheet. Again, if you utilize this tool and view the worksheet PDF, it'll generate an exact replica of our sentencing guidelines worksheet that you could then bring to sentencing. It's also, I know a lot of states attorneys also use it just to calculate sample guideline scenarios prior to officially initiating a worksheet in MAGS. So again, I just wanted to point out that tool while we're here for the webinar this afternoon. So before we conclude, I just want to quickly highlight two additional recent and notable updates to the sentencing guidelines. The first is that following a review of sentencing guidelines compliance, the MSCCSP approved during its December 7, 2021 business meeting, revisions to the sentencing matrices for drug and property offenses. So these pending revisions are anticipated to go into effect on July 1, 2022. So let's take a closer look at how the sentencing matrices for drug and property offenses will be revised. So this image here, it illustrates the current and approved revised ranges for the drug matrix. So you can see we have 2 rows of information that are listed for each cell. Row 1 in the black font, that provides the current guidelines range. And this will continue to be the recommended guidelines range for cases sentenced before July 1 of 2022. Whereas row 2 in the red font, this provides the revised guidelines range and will be the recommended guidelines range going into effect on July 1 of 2022 for cases being sentenced on or after that date. Now, in accordance with this July 1, 2022 effective date, the Maryland Automated Guidelines System and the Guidelines Calculator tool will also be reprogrammed in order to account for these revisions to the sentencing drug and property matrices. So since guidelines worksheets are often initiated in MAGs several weeks in advance of sentencing, effective July 1 of 2022, you will start seeing an alert message populating. As we see in this screenshot here, when calculating guidelines for an offense seriousness category and offender score combination, whose guidelines range will be revised effective July 1. So practitioners will then select whether the sentence date will take place on or after July 1, 2022, and the guidelines will be calculated accordingly. However, I do want to note that should the date of sentencing be postponed or moved up, the guidelines will be automatically updated in MAGs to correspond to those in effect based on the sentencing date that is entered on the GLS overall sentence tab. Now, for anyone who's interested, resources pertaining to these pending revisions to the sentencing drug and property matrices, they can be accessed from our commission's website. So on March 16th of 2022, if you subscribe to our guidelines listserv, you know that a memo detailing the cell-by-cell compliance review process, implementation plan, and revisions to the matrices was distributed to the commission's listserv. It can also be accessed from our website at the address noted here on this slide. Further, I also just want to note that MSCCSP staff will be holding additional webinars throughout June to explain more about the review process that led to these revisions, to highlight these pending revisions in greater detail, and to review common questions relating to the pending revisions. So if you or your colleagues are interested in attending any of these webinars, we certainly encourage you to register via our training page at msccsp.org/training. And the final update I want to review is the classification of third-degree sex offense. So on September 14th of 2021, the MSCCSP voted to revise the seriousness category for sex offense third degree involving age-based elements in light of 1, concerns from multiple practitioners that the previous seriousness category of 5 was too low, and 2, an analysis of sentencing data that identified sex offense third degree involving age-based elements as the offense with the highest rate of sentencing departures above the guidelines. Therefore, effective February 1 of 2022, the seriousness category has been revised from a seriousness category 5 to a seriousness category 4 for this offense. So I'm going to wrap up by highlighting a few of the commission's resources. So the MSCCSP website, it's continually updated throughout the year, and it's a really useful resource for any individuals who implement and calculate the sentencing guidelines. It includes annual reports that are a great source to learn more about recent sentencing trends and the work of the MSCCSP. We also have our guidelines e-news that can be accessed, and they help to inform about the changes to the guidelines. More recently, the MSCCSP started production of a series of topical mini reports titled Sentencing Snapshots, which are intended to provide a quick review of sentencing trends and other topics of interest. So this most recent issue of the Sentencing Snapshot, it took a closer look at sentencing trends in Maryland circuit courts for marijuana offenses. So all of our sentencing snapshots are available on our website. And I have to give a big shout out to my colleague, Sarah Bowles, who puts these snapshots together. She does a phenomenal job, and we've gotten a lot of positive feedback in response to them. So again, those are available on our website if they may be of interest to you. We also have our guidelines manual and guidelines offense table in PDF format, as well as access to the MAGS and guidelines calculator tool. We have various instructional videos, including guidelines training webinars that can be accessed from our training page on our website. We also have a YouTube channel. So if you clicked on the training video link from our training page, it'll take you to our YouTube channel, or you can just simply go to YouTube and type in MSCCSP, and you'll see various training videos populate on our YouTube channel. Oh, I'm sorry, here was a screenshot of our training page where, again, you can sign up for webinars and where we have these training videos here that you can take a look at. And then finally, we have our help desk, which is manned from 9 a.m. to 5 p.m. every day. You can feel free to call us at 301-403-4165 or contact us via email at msccsp@umd.edu. And of course, we're always happy to answer any questions that you may have. So this concludes the webinar. I just want to touch base with my colleagues, Sarah and Stacy, to see if there's anything outstanding that we want to address before we wrap up here.
There are no outstanding questions in chat, Catherine. I did kind of prompt people if they had any last minute questions to submit them, but I think we are good to go.
Okay, great. Thank you so much, Stacy. And thank you everyone again for participating. Hope you found it to be very informative. We will continue to hold these webinars on a consistent basis. So, feel free to sign up for a future training, and we hope you enjoy the rest of your day. Thanks so much.